When the SAFE Act was published, model language was provided by the CSBS and the AARMR to the states for use when revising their existing laws. This was done so that the states could easily adopt the federal SAFE Act into their respective state law. In doing so, regulatory authorities which already existed within our industry were identified as either the Department of Financial Institutions or the Mortgage Regulatory Commission. In each instance, a superintendent or a commissioner is identified as in charge and is given certain powers known as responsibilities and limitations. The Federal SAFE Act's purpose is to protect consumers seeking mortgage loans and to ensure that the mortgage lending industry is operating without unfair, deceptive, and fraudulent practices on the part of MLOs. This law, when adopted into state laws, gave commissioners the power to deny, suspend, revoke, condition, or decline to renew a license for a violation of this Act, rules or regulations issued under this Act, or order or directive entered under this Act. Also gave them power to deny, suspend, revoke, condition, or decline to renew a license if an applicant or licensee fails at any time to meet the requirements of the law or withholds information or makes a material misstatement in an application for a license or renewal of a license. It also gave them the power to order restitution against persons subject to the Act for violations, and finally, the power to impose fines on persons subject to the Act. The law also gave commissioners the power to issue order or directives under this Act, such as the following: to order or direct persons subject to this Act to cease and desist from conducting business, including immediate temporary orders to cease and desist, and to order or direct persons subject to this Act to cease any harmful activities or violations of this Act, including immediate temporary orders to cease and desist. The Commissioner may also enter immediate temporary orders to cease business under a license or interim license that was issued. The Commissioner may impose a civil penalty on an MLO or person subject to this Act if the Commissioner finds on the record after notice and opportunity for hearing that the mortgage loan originator or person subject to this Act has violated or failed to comply with any requirement of this Act or any regulation prescribed by the Commissioner under this Act or order issued under the authority of this Act. Furthermore, each violation or failure to comply with any directive or order of the Commissioner is a separate and distinct violation or failure. In addition to any authority allowed under state law, a state licensing agency has the authority to conduct investigations and examinations. For the purposes of investigating violations or complaints that may arise for the purposes of examination, the state licensing agency may review, investigate, or examine any loan originator licensed or required to be licensed as often as necessary in order to carry out the purposes of the law. Each loan originator, meaning company, must also make available upon request to the state licensing agency the books and records relating to the operations. The state licensing agency may have access to the books and records and interview the officers, principals, loan originators, employees, independent contractors, agents, and customers of the licensee concerning their business. This authority remains in effect whether a loan originator acts or claims to act under any licensing or registration law of such state, or claims to act without such authority. No person subject to investigation or examination may knowingly withhold, abstract, remove, mutilate, destroy, or secrete any books, records, computer records, or other information.